two cases that we have, two recent cases of ours. One, which was tried in New York last April, the Harry Potter lexicon case, that's Rowling versus RDR Books, and the other is a current case that is just getting underway, Shepard Fairey's lawsuit against the AP and the Obama Health Trust. So I'm just going to, talk in general terms, and happy to have as much time as possible for questions and discussion after my presentation. So what is so critical about fair use and defending cases that involve fair use questions? It is a determination that's made on a case-by-case basis. So it is important that cases that involve the fair use defense are litigated and so that the law can become more clear. That's the idea of the fair use project. And that's the idea of this topic being the bounds of fair use, how the cases impact where the line is drawn between what is fair and what's not fair use. But fair use serves a very critical purpose in our society. It is essential for freedom of speech. My boss, Tony Falzone, likes to say he would rather our project be called the Free Speech Project. So copyright law at its heart gives copyright owners a monopoly over their works. That right allows them to control the work, allows them to control reproduction, distribution, production of derivative works, and other rights. So what that essentially means is that copyright holders can tell other people, you can't say this. These are my words, this is my story, this is my work. You can't use this speech. So what fair use does, so obviously that creates a conflict between what the copyright law does to protect copyright holders and what the First Amendment does to protect all of our rights to speak and to have freedom of speech. Fair use actually acts as kind of a lubricant in that conflict. It creates a space for creativity and speech that builds off of and uses existing copyrighted works without being totally subject to the control of the copyright holder. So the other important factor of fair use and copyright law in general is that to remember that the purpose of the Copyright Act is to promote science and the useful arts. So it's to incentivize creators. So you can incentivize creators by giving them a monopoly, but if you create too much of that monopoly, you squelch the creativity of other people who would be creating off of the culture that exists around us. Okay, so in a lot of our cases, this kind of issue comes up where why rely on fair use? Why don't they just pay a license? Isn't this just about money? It is very much not about money in a lot of cases. When you require somebody who is creating a new work to get a license, what you are also requiring is that the original copyright holder gives permission. So they have this control over what you are saying and what your message is. So that the author of a copyrighted work may refuse because they disagree with your speech, or they disagree with you personally, or your point of view, or the people that you represent. So, and they may disagree with not wanting to have any association with what your work is, or to disclaim any kind of association with a particular message. So they may want to control your ability to use their work for those reasons. In other instances, the licensing system just breaks down, and then the licensing system can break down for a whole number of reasons. But one of them is, it's often, very expensive. And so if we required only a license, that would a system where there wasn't any kind of fair use, that would mean only the most affluent creators authors could, you know, afford to pay licenses and afford to negotiate those licenses. So without, you know, allowing creative expression based on the culture that is around you, based on works that have come before today, everything that is building off of our common culture, without, you know, a fair use right, a lot of that creativity would be stifled. We would hear fewer points of view and general diminishing of creative expression. So where the line is and what the bounds are of fair use, you're trying to really just provide this balance between incentivizing copyright holders, providing them the protection that they need to be incentivized to create in the first place, and you know, mediating between the interests of free expression. So the fair use test is set out in 17 U.S.C. section 107, and it has 4 statutory factors. They are intended to guide the court's decision on fair use. They're not exclusive. They're to be read together and balanced in light of the purpose of the Copyright Act. So the first factor being the purpose and character of the use. This factor looks into what is the secondary work, what is the purpose of this work, and the key question there is it a transformative use of the original copyrighted work? Sub-factor within that first factor is whether the use is commercial or non-commercial. Courts routinely recognize that almost every creative work these days has some commercial value, so whether it's commercial or non-commercial has less importance. The second factor, the nature of the original work, goes to whether the work that you are using and relying on for the second work, if the original work is a creative work or if it's more of a factual work, so whether you're talking about a news story or that kind of thing as opposed to a fictional creation. Third factor, amount and substantiality of the portion used, looks to how much of the original work have you used in light of, this factor is in light of the purpose that you're using it for, so how